agents to it makes it unlawful for these types of entities to discriminate against people based on a protected class, in most commonly the sale or lease of residential housing. We'll go over those specific types of conduct that the Act prohibits, and those protected classes include race, color, religion, sex, familial status, national origin, or disability. Sex includes gender as well as orientation and or identity, and it protects members of the LGBT plus community and beyond. Familial status includes a person a parent or person with custody with one or more person under the age of 18. It also includes anyone who is pregnant and or someone who is in the process of securing legal custody. The Tennessee Human Rights Act also identifies another class of individuals that it protects, and it prohibits discrimination based upon what has been termed creed. Creed would include a certain foundation or system of beliefs, and one example of that would be someone's choice in denomination. Some of the prohibited activities under the Fair Housing Act, and these activities are prohibited when they're done based on a protected class. So the refusal to rent, sell, negotiate, or otherwise make unavailable the sale or lease of a residence. And some examples would include delaying tactics in sale or rental of a residence, creating different or a more complicated procedure in application process to pursue a residence, grudgingly making housing available, or making people feel unwelcome. Another prohibited activity under the Fair Housing Act are creating a difference in terms, conditions, privileges of sale, or the rental of a dwelling, or the provisions of services or facilities in connection with living in the dwelling. And excuse me, when I say dwelling, I just mean a house, home, a property where somebody's going to reside in, and basically their daily life activities. Some examples of that are demanding higher down payments or prices from members of a protected class, applying different terms that are higher to meet for members of a protected class, denying facilities or services to members of a protected class, or providing more favorable conditions or terms, such as special to members of one class, but not to their counterpart. More prohibited activities under the Fair Housing Act include—
Hey, Erica, I think we have a question.
Okay.
Hi, this is Valerie Hughes. My question is, on your last screen, it talked about those things that are prohibited. How would we know if they're getting higher, they're being asked for higher down payments, or theirs is different? How would we know that to be true?
Erica, I'm going to jump in on this one for just a second.
Sure.
Thank you.
You can't always know, and that is a struggle with a lot of times in proving any kind of discrimination across the board. A lot of this is just if you can kind of gather some proof, and often it's a tenant is living there talking to their neighbors and they're hearing these things. So most people now are kind of smart enough to not be too explicit with their discrimination, but we can often find things. People are not as careful about what they say to people as they are about what they write down. And that's still evidence of a disparate impact, of disparate treatment going on. And so like I said, it's hard to prove. It's not like they're going to say you are this kind of person, so you're getting this deal, but you can talk to the neighbors and you can find out who is being treated in which favorable ways.
Okay, thank you.
Okay, is that all the questions that we had right so far?
I think so. And I'm watching the chat. So if anyone has questions for the chat or raise your hand, we're keeping an eye on it.
Thank you, Trina. So additional prohibited activities under the Fair Housing Act, and sorry, I need to change my slide. are the print or publication of discriminatory statements, limitations, or preferences. Those examples would include newspaper ads that indicate whites only or white home, steering people to an area with statements that encourage one area over another based on a protected class, placing or enforcing restrictive covenants and deeds, denying the availability of a residence based on the status of someone being a protected class is also a prohibited activity. The two examples that we have are a Hispanic couple is told that a particular unit is sold, and the couple discovers several weeks later that the dwelling remains available and was for sale when they inquired. Another example, when the wife, who is white, visited the condo complex, she was told that there were several units for sale. But when her husband, who is African American, later in the day visited the complex with her, they were told that all units were sold. Discriminatory lending practices are also prohibited by the Fair Housing Act, which would be an example, imposing a higher interest rate because of race, not making loans to non-white individuals for homes in majority white neighborhoods, taking a longer time to process a loan because the borrower is a member of a protected class, taking a longer time, redlining an area that is predominantly Black and refusing to make loans within that area regardless of qualifications for the loan, or reverse redlining an area that is predominantly Black in order to offer loans that the lender is aware borrowers will be unable to repay, with disadvantageous terms and conditions attached. And more prohibited activities are threats of intimidation or coercion, which is graffiti written on or about the individual's property, acts of vandalism or violence against an individual or their home. And this third one is more so applicable to employees when they're the subject of retaliatory conduct because they decide not to discriminate against prospective home seekers because of a class or membership at the direction of their employer. Blockbusting, one example of that is in order to make money, an agent asks homeowners to let the agent sell their house because African Americans are moving into the neighborhood, and the agent tells the homeowners that the property values will decrease because of it. Or placing leaflets around a neighborhood about who a protected class member is moving into the neighborhood in order to scare people into selling their dwellings and offering to help them sell their house. And I do want to say, although these examples that I've been listing may have specific designations of protected classes, such as African American or Hispanic, if this type of activity is occurring against any of the protected classes that I previously mentioned, race, color, religion, sex, familial status, national origin, or disability, then the examples are still going to apply. The Fair Housing Act also protects against disability-related issues, and the term handicapped is what is used in the Fair Housing Statute, that's defined as a physical or mental impairment which substantially limits one or more major life activities, a record of an impairment, or being regarded as having such an impairment, whether that person has an impairment or not. Major life activities could be caring for oneself, performing manual tasks, walking, seeing, hearing, breathing, learning, or working. Disabilities, these are examples of disabilities protected by the Fair Housing Act, but this is not limited by these examples. They're just examples. Anyone suffering from Alzheimer's, people suffering from senile dementia or organic brain syndrome, people who are limited by developmental disabilities, elderly people suffering from chronic illness, people with schizophrenia, people diagnosed with HIV or other infectious diseases, and people who are mobilely impaired. Examples of prohibited activities regarding persons with disabilities are a refusal to sell a house to a person because the individual has AIDS or any other limiting infectious disease, a refusal to negotiate the price of a dwelling because the individual is mobilely impaired, The sale office is not accessible for persons who are mobilely impaired, or denying access to a swimming pool to a person who is mobilely impaired because of that impairment.
And sorry, Eric, I want to jump in really quickly. As we're talking about disability, just so for everyone's knowledge, this is the biggest category of discrimination that we see at Legal Aid, and also that HUD sees when we've been at meetings with them, that they say they see across our region and across the country. Disability issues are far and away the largest. So the other ones are also very significant and important, but I just want to bring a little attention to that. Sorry, Erica.
No, that's okay. Thank you, Trina. In regard to a disability, one thing that these people are entitled to have when they are renting are reasonable accommodations and modifications. A reasonable accommodation is a change of the rules, policies, practices, or procedures of a property. And examples of those include assignment of a parking space when you typically have a first come, first served policy, approval of an assistance animal when there is typically a no pets rule. A reasonable modification is a change to the physical structure of the property. An example is installing a ramp or grab bars for a person who's mobility impaired, changing the locks on a unit due to the needs of a tenant. Reasonable accommodations is unlawful for an entity who's covered by the Fair Housing Act to refuse to make reasonable accommodations to rules, policies, practices, and services, when such may be necessary to afford the individual the equal opportunity to use and enjoy the dwelling. Examples of a failure to reasonably accommodate are refusal to permit a mobilely impaired person a designated place near their entry when such is necessary due to their disability. An apartment complex with a no pets policy, if they refuse to permit a pet to reside with a person with mental illness when the pet is necessary to their mental well-being. Charging a pet deposit to a person with a sight impairment to have a seeing dog reside with them. And then there are some examples of unreasonable accommodation requests by a tenant, because everything is not free game. Jane, who is blind, has a service animal who helps her get around. She requests that a maintenance worker walk the dog 3 times a day. Or Joe has diabetes, his nurse is on vacation, so he asks that someone from the office assist him with his insulin shots twice a day. Those are not going to be reasonable requests made by someone with a disability. Reasonable accommodation best practice is to make any reasonable accommodation request in writing. The requests have to be made for the landlord or renter to be required to accommodate. If the disability and the need for the accommodation is obvious, it's inappropriate for a landlord to ask for documentation of the disability. One example of that might be handicap parking for someone who already has been designated a person who needs that, and they have the documents and the placard to show that. Otherwise, the landlord can ask for documentation of the disability, a description of the needed accommodation, and an explanation of the connection between the disability and the requested accommodation. That documentation can come from a wide variety of sources, such as a doctor or other medical professional, a peer support group, a non-medical service agency, or a reliable third party who's in the position to know about the individual's disability. Reasonable modifications, that is a change to the structure of the residential premises, and the tenant is generally responsible for those costs to modify the structure. Under the Fair Housing Act, it is unlawful to refuse to permit, at the expense of the person with a disability, reasonable modifications to the dwelling. And those reasonable modifications do need to be necessary to afford the full use and enjoyment of the premises. Examples of prohibited conduct are the refusal to permit a person who is mobility impaired to build a ramp to the main entrance of their house, the refusal to permit a person to install studs and grab bars in the bathroom of their home, refusal to permit doors to be widened in order for a person in a wheelchair to move through the dwelling, refusal to permit removal of cabinets under the sink in the kitchen so that a person with a wheelchair can reach the sink. When it comes to a reasonable modification, the landlord can request documentation unless the need for the modification is obvious. Methods of documentation can come, again, similar to reasonable accommodation, from a doctor or other medical professional, a peer support group, a non-medical service agency, or a reliable third party who knows about the individual's disability. When it comes to making a reasonable modification in a rental situation, the landlord can condition modification upon the renter restoring the interior of the condition existing before the modification. So if someone requires a modification be made, there are circumstances where the landlord can request that that condition be unmade, basically, to restore it back to its original condition. The landlord cannot require removal or restoration of modifications to the interior of dwellings unless they affect subsequent tenants' use. Generally, the landlord cannot require removal or restoration of modifications to common areas or dwelling exteriors, and modifications that would assist the next renter need not be restored. So the removal of grab bars in the bathroom or doors that have been widened do not have to be restored. Again, the tenant best practice is for the modification to be made in writing. It has to be made. And with regard to a reasonable modification or a reasonable accommodation, a flat out denial of the modification is never going to be appropriate. The landlord may discuss a request with the tenant and reject the request as unreasonable, but then the landlord should discuss alternatives with the tenant that's going to help them with the use and enjoyment of their property. A landlord should not propose alternative accommodations if the requested one is reasonable. When it comes to the preferences of the landlord and how the modifications are made, if the modification to the interior of the unit must be restored at move out, the landlord cannot dictate a particular design for aesthetic reasons. If the modification is to a common area or to the interior of the dwelling and will remain after move out, the landlord may be able to dictate a design if it imposes no additional costs on the tenant. Landlord cannot dictate a particular contractor. They can require that the modification be done in a workmanlike manner, which basically means probably no fix it yourself. The landlord can require that all necessary building permits be secured for modifications. And that brings us to the end of our slide. If you think that you see a fair housing issue or the Fair Housing Act has been violated, please call myself, or you can even contact Trina, which by her email provided here on this slide. There's also avenues for correction through the Tennessee Human Rights Commission or the or HUD, the Department of Housing and Urban Development. Does anybody have any questions? Oh, sorry, go ahead, Trina.
I was going to ask the same thing.
I have a question. There is a city ordinance in Clarksville that has to do with fair housing that's being formed now, and I'm wondering if there's a need for such a city ordinance, a fair housing ordinance within a city, or is that redundant considering what is, what's stated in the Fair Housing Act or other laws that secure the rights? Is it redundant, or is there a need? Is there a purpose for that? And if so, how can that distinguish itself from the other remedies that are out there?
Yeah, I guess it's hard to say, because if it's going to protect different classes or different categories or different situations, then maybe it's going to be helpful. If it's just going to restate exactly what's already there, maybe it's nice, but not needed. It's hard to say. It's so specific on the dependent on the specifics. Got that backwards. Oh, I lost my train of thought. I started seeing all the chats coming in.
Well, I can. If you want,
Oh, I was going to say some areas, for instance, have like types of income are a protected category. So there are different places that have different protected classes than we have in Tennessee. So it is
Mhm.
something to consider.
And how about a complaining, is there a need for the ability to make a local complaint versus some other avenue?
You know, I think that it would really depend on the language of the ordinance and what exactly the ordinance is doing in conjunction to the Fair Housing Act. Because I would say that if you can enforce these types of things and these
Locally.
violations on a local level, then it's going to be better than for it to not be there. HUD is a very large organization, and they're, you know, that's a federal enforcement that HUD is doing. So again, if you can enforce something on the local level, I don't think that it's redundant, would be my personal opinion. Hey, Valerie, did you have something to?
Just to piggyback on that, for as far as local, for basic things like building code can help solve some things. If you go into a house and then say it's got mold or they haven't fixed the thing. Yes, you can go through fair housing, but you can go through your local buildings and code, and they can also establish a fix order on it or condemn a building. So it's a lot quicker than waiting. Not that I'm not saying not to, but to get something fast. On those basic surface levels, this aesthetics of a building or the lack thereof take care of. The buildings and codes can help take care of that. I just wanted to put that out there. And I wanted to know, Rob, did you know what the ordinance was that's being proposed by this city?
It's called the Fair Housing Ordinance, as far as I think that's, so it's under consideration. It's on the book, so it's being revised.
Okay. Thank you, Valerie, and thank you, Rob, for the question. That's a good thing to look out for. I wasn't aware of that. Do we have any more questions? Okay, I'm not sure that we do, but again, if questions do come along, then please feel free to reach out to me. You can call me and I'll put this back up. You can give us a call or email and ask your questions. I also really want to thank everybody for coming out today. I really appreciate you being on here, and I look forward to seeing you guys around. Trina, do you have anything to add?
No, thanks everyone for letting us do this. This has been great.
We really appreciate your time. And we hope to see you on the next webinar as well.